When it comes to any commercial dispute, there's one question you absolutely have to answer first. And if you get it wrong, well, your case could be over before it even starts. So today, we're going to break down that single most important question.
Okay, let's just imagine this for a second. Picture it. You own a business, you just shelled out for a brand new top-of-the-line refrigeration system, and it dies overnight. Poof. $50,000 of your inventory is just ruined. You're furious, right? You're bleeding money, and you want someone to pay. What's the very first question that pops into your head?
I bet for most of us it's who's to blame, right? Was it the manufacturer, the guy who installed it? But here's the twist. In the world of commercial law, that's actually the wrong question to ask first. The real game-changing, absolutely critical question is way more basic. It's what law applies here? Because believe me, the answer to that question changes everything. And this whole process, figuring out which legal rulebook you're playing by, it's got a name. It's called scope analysis. It is the essential first step, and that's exactly what we're going to dive into today. So, here's what we've got on tap. First, we'll tackle goods versus services. Then we'll get into the whole lease versus disguised sale thing. After that, we'll touch on some big rules that can change the game, and we'll finish up with a handy checklist to put it all together. Sound good? Let's go. All right, let's jump right in. First up, goods, services, or both. Think of this as the first major fork in the road, and which path you go down, well, that sets the course for your entire legal battle. Okay, so the main set of rules for sales is something called the Uniform Commercial Code. Everyone just calls it the UCC, and it only applies to transactions in goods. So what's a good? The UCC keeps it pretty simple. It's basically anything that's movable when you make the deal. Cars, computers, a pile of lumber. The easiest way to think about it is if you can pick it up and move it, it's probably a good. But, it's not always that clear-cut. What about something like a custom-designed, professionally installed doggy door? I mean, you're getting a thing, right? The door. That's a good. But you're also paying for a service, the design, the installation. This is what lawyers call a hybrid transaction. So now what? Do we use the UCC for goods or the old common law rules for services? It's a real puzzle. To figure this out, courts have a tool called the predominant purpose test, and it's actually a really elegant idea. The judge just asks, what was the main point of this whole deal? What were you really after? Were you buying a product and the installation was just a little something extra? Or were you really paying for that contractor's skill and time, and the parts were just, part of the job? So how do they decide? Well, they look at a few clues. First, they'll check the contract itself. What words did you use? Purchase or installation? That's a big hint. Second, they'll follow the money. If the materials were, say, $500, but the labor was $2,000, that screams service. And third, they'll look at the supplier. Is it a huge store that just sells stuff? Or is it a specialized contractor who mainly sells their skills? And trust me, this isn't just some boring legal theory. This distinction can have massive real-world consequences. Let's take a look at a real case, Heron Farms. A giant 115-foot grain elevator just collapsed only 6 months after it was built. This case just lays out the stakes perfectly. The farmer sued, of course, but the whole thing hit a wall. The statute of limitations, basically the deadline to file a lawsuit. If the court called it a sale of goods, the 4-year deadline was up. No lawsuit. If it was a service contract that wasn't signed, the 3-year deadline was also up. But if it was a signed services contract, that had a 5-year deadline. And suddenly, the lawsuit was back on. In the end, the court said it was a service because of all the skill needed to install it. A $500,000 case. All came down to that one single decision. Was it a good or a service?
All right, let's move on to our next big question. Because sometimes what looks like a lease and talks like a lease is actually just a sale in disguise. And the law has to be able to tell the difference.
So why does this even matter? Oh, it matters a lot. For 2 huge reasons. First, think about selling something. If you're just leasing it, you can't sell it, right? You don't own it. But if it's really a sale in disguise, then you do own it and you can sell it. And second, and this one is a really big deal, bankruptcy. When someone goes bankrupt, a trustee can take all the stuff the person owns and sell it off. But if something's just being leased, the original owner gets it back and the bankruptcy court can't touch it. We're talking about a distinction that can be worth millions.
So how do we figure it out? The UCC actually gives us a nice, clear roadmap. Step 1 is simple.
Can the person leasing the thing just walk away from the deal anytime they want without a huge penalty? If the answer is yes, it's probably a real lease. If not, we go to step 2, the UCC's Bright Line test. This basically asks if you're going to end up paying for the entire useful life of the item anyway. And if things are still murky after that, you fall back on the economic realities test. And this brings us to one of my favorite cases in this whole area of law. It's called the Purdy case, and it was all about leasing dairy cows. Yeah, you heard me. A farmer was leasing hundreds of cows, he went bankrupt, and the whole mess landed in court. The big question, was it a real lease, or was he just buying them on an installment plan? And the court was totally divided on this. It just shows you how tricky this stuff gets. The majority looked at it and said, the good here isn't one cow, it's the whole herd. And a herd is always replacing itself, so it has a super long economic life. This is a true lease. But then you have the dissent, the judges who disagreed, and they had a completely different take. They said, no. The good is each individual cow, and a single cow's useful, milk-producing life is way shorter than the lease term. This is a disguised sale, plain and simple. And the dissenting opinion had this amazing line that really captures their thinking. It reframed the whole thing. A cow wasn't just livestock. It was a sophisticated piece of equipment that produced a product, milk. Wow. By saying that, they completely changed the economic picture. It's just a perfect example of how two judges can look at the exact same set of facts and come to completely opposite conclusions. Okay, so let's move on. Up to now, we've pretty much been living in the world of the UCC. But you have to know there are other big laws out there that can swoop in almost like an overlay on a map and completely change the rules of the game. The two big ones you really need to have on your radar are the CISG and the Magnuson-Moss Warranty Act. The CISG, that's a treaty for international sales of goods. And since it's federal, it can actually override the state-level UCC. Then there's Magnuson-Moss. That's also a federal law, but its whole job is to give regular consumers extra protection when it comes to warranties. And this is where it gets really interesting because they define things differently. Look at how they decide what's a consumer product. Let's say a restaurant owner buys a car. Under Magnuson-Moss, the test is objective. The law asks, are cars normally used for personal stuff? Yep, so it's a consumer product, and the law kicks in. But the UCC uses a subjective test. It asks, what is this specific buyer using it for? Well, she's using it for her restaurant deliveries, so that's a business purpose. Under the UCC, it's not a consumer good. It's the same car, same deal, but you get two totally different legal answers, and that means very different rights. Whew. Okay, so we have covered a ton of ground. Let's pull this all together now into a simple, practical checklist you can actually use when you're thinking through this stuff. The real key here is to go through these questions in order. Step 1, are we dealing with goods, things that are movable? If it's a mix of goods and services, then you have to use that predominant purpose test. If the contract calls it a lease, you got to double check if it's actually a disguised sale. Are the buyer and seller in different countries? Then you need to see if the CISG applies. And finally, is it a consumer product? If so, you have to check if Magnuson-Moss gives you extra rights. If you follow this checklist, you'll be starting on the right legal footing from the get-go. See, by starting with that one simple question, what law applies, you figure out the rulebook for the entire fight. It is the absolute non-negotiable starting point. But answering that question, that's really just opening the door. Because the answer then leads you into the really complex stuff, the worlds of warranties, remedies, and damages. And that is where the real battle begins.